Very well. We will then continue this transmission of the Fourth International Forum on Environmental Justice after this first break. We remind you that you can participate in this meeting through the chat that has been specially enabled to receive questions addressed to the speakers of each panel. These will be channeled by the moderator and raised at the end of all the presentations. It is now time to present the second panel, Climate Change, which is integrated by Mrs. Maisa Rojas. She is professor associated with the Department of Geophysics of the Faculty of Physical and Mathematical Sciences of the University of Chile. Mr. Daniel Klein, international lawyer and climate change expert from Germany. Mrs. Christina Floyd, professor in the Department of Public and International Law in Oslo, Norway. And also Mr. Maxx Dilley, director in charge of the climate program of the World Meteorological Organization and deputy director of the Department of Services of the same organization. This panel will be moderated by Mrs. Sibel Villalobos, Science Minister of the Third Environmental Court. Minister, the floor is yours.
Many thanks. First of all, I would like to welcome all who are participating in this broadcast. And I would also like to give a special welcome, full of gratitude to the speakers who are joining us today on the panel, in which we are going to refer, extensively, to the topic of climate change. Climate change has undoubtedly been the most relevant issue in recent decades, probably with the loss of biodiversity at its multiple levels. And the next IPCC report expected for 2022 will be able to continue guiding what has been a place of debate that it has not known borders between nations, and neither between disciplines that are addressing this issue. I believe that it is necessary to understand the phenomenon of climate change from science, to have more and better forecasting mechanisms, in this way facilitating adaptation. But it is also necessary to understand the balance of benefits, risks and damages for all of us. Human beings who are trying to tackle this problem together. In this way, we can approach adaptive strategies that are also equitable for all humanity, which is an unprecedented challenge for the history of mankind. And to delve a little into this matter, we have the distinguished participation of 4 experts worldwide, from various nations with various specialties. We have a Chilean physicist, a German lawyer, a Norwegian lawyer, and an American geographer, who are going to share with us their insights and discoveries on this relevant subject. Each of the exhibitors will have 20 minutes for their presentation. I will let you know when you have the last 5 minutes left. And before we begin, I would like to remind the attendees that in the comments area below the transmission of the forum website, they can ask the panelists questions through this chat system, in such a way that at the end of the last presentation, the questions will be put to our speakers. First of all, I am going to leave Maisa Rojas with all of you, who, as I had told you, has a degree in physics from the University of Chile. She has a doctorate in atmospheric physics from the University of Oxford. She is specialist in paleoclimate and climate change. She was coordinator of the advisory team of the COP25, organized by our country. And she is currently actively organizing the preparation of the IPCC report. Well, good afternoon, everyone. Thank you very much for the invitation to share my experience in the role of science in the issue of how a country faces climate change. As I am a scientist, I am going to make the link, on one hand, on legal issues. What is the Paris Agreement? Which is the instrument that orders us to work together towards the ultimate goal. And I am going to relate then, this international agreement
with the physics behind it, the objective behind it, the temperature, the carbon budget, the carbon neutrality. I will talk a bit about the climate change law in Chile, and in particular what role science has played in the things that have happened in the last 2 years in Chile. We all know the Paris Agreement was agreed in 2015 at COP21, and in its Article 2, the objective appears. And the target is a temperature target. It is then described in terms of temperature. And the goal is to limit warming to well below 2 degrees, and to make every effort to limit it to 1.5.
Así que ahí tenemos la primera vinculación de que en realidad el objetivo se mide en temperatura.
The truth is that at that time, in 2015, the scientific world had done little to define what this meant by delimiting warming by 1.5 degrees. And therefore, it was the same convention, the same parties that asked the IPCC, the Intergovernmental Panel on Climate Change, and which is an independent entity, to provide a report that could enlighten us on what this objective, that is within the Paris Agreement. Here is the long title of the report that today is known as the 1.5 report. In my opinion, it is the most influential report of the IPCC. And the IPCC is asked not to talk only about climate change, and it appears here. You can see it. It is all in the context of sustainable development and efforts to eradicate poverty. That is, to link our effort for climate change with the other objectives that we have set ourselves as humanity. And very briefly, these are the 3 headlines of the Paris Agreement. Half a degree counts. And what this tells us is that effectively a world that heats up by 2 degrees is a very different world from one that manages to limit warming to 1.5 degrees. That is, it is worth the effort to achieve this more ambitious goal within the Paris Agreement. And what the report does later is to see if this is even feasible. And luckily the answer is yes. This is feasible. There is feasibility, and for that, every year matters. In other words, there is a level of urgency to be able to achieve these objectives, and then the third question is, how do we achieve it? And the conclusion of the report is that this is not only going to be achieved by the countries, in a central way, but they are going to have decisions and contribute regions, cities, and the private sector, civil society. So, every decision counts. And as for the question of how we managed to limit warming to 1.5 degrees, the report has a full chapter on trajectories. What should future development be like, and what transitions are we going to have to implement to achieve this goal? And this is where I want to stop very briefly, because this is the most scientific part. The knowledge generated, I would say, in the last 10 years. That the first article that appears on this subject is from 2009 or 2010, and that there is a relationship between emissions, which are the parts that humans make. We burn fossil fuels, and that injects CO2 into the atmosphere. CO2 concentrations, which is how much CO2 is left in the atmosphere. And that is eventually what produces the difference in the energy balance, and its response that we measure in terms of temperature. And it turns out that the increase in temperature of the planet is related to an amount, which is the accumulated emissions.
In other words, and here appears for the first time then, the concept of carbon budget. Given a temperature limit, which in this example is 2 degrees, thus says the Paris Agreement, but it could be 1.5, it could be 3, or it could be 4. Given this relationship, this is associated with a carbon budget, accumulated emissions. The important thing is to see from here that in this budget there is an amount of CO2 that is already in the atmosphere, and therefore there is a remaining CO2 budget. This is a picture, also from the report. It is a bit complex, so let me introduce it to you in more detail. Here we have, on the one hand, the years on that axis, we have CO2 emissions. And here is a line where the sea is. And each of these lines that appear on this graph, on these axes, are possible future trajectories. That is, there is not a single possibility. There are so many options for how we can achieve this goal of limiting warming to 1.5 degrees. What we have then is a budget. Technically, this is the area under the curve. It is a finite amount of CO2 that can still be injected into the atmosphere. And there, it appears then, that of all these different options that exist in the literature, more or less all, by the year 2050 reach this zero. And therefore there appears the commitment of carbon neutrality to the year 2050. Other elements that include, and here I make the relationship with the Paris Agreement to the year 2030, there are the intermediate goals that appear in the nationally determined contributions. What the report says is that, by the year 2030, these emissions should be practically half of what they were in 2010. And finally, there is also another important concept, and that is, since emissions are increasing, a peak year must be defined. A year of the maximum, and after which all global emissions will go down. Another way to see it is that we present this carbon budget as a cake, in which the blue part is the part that is already in the atmosphere, and there is this remaining carbon budget, which, as you will see, is quite small. And if we continue at the rate of current emissions, it runs out in a short time, in the year 2027. That is the scientific part that supports the Paris Agreement. In 2019, Chile makes the decision to be the presidency of the COP25, and in that context, Chile adopts the commitment to be carbon neutral in 2050. That commitment was not previously, it was not in the government program, so I dare say, this is a direct consequence of Chile taking over the presidency of the COP. For the organization of the COP25, Chile created a scientific committee to support the work, which managed to convene more than 600 scientists, and which I had to lead. Chile updated its Nationally Completed Contribution, or NC for its acronym in English, where it includes the commitment to carbon neutrality, and Chile also proposes a change to the framework law on climate change. This was within the government program, but this project now includes carbon neutrality by law, and also includes a scientific advisory committee. Some of the great milestones that have occurred, I would say, in a very synergistic way, with the fact that we still have the presidency of COP25.
One of the specific issues that we work on in the scientific committee, the work was divided into a number of tables. There was one focused on the issue of mitigation and energy, and it was a table that worked closely with the ministries in charge of updating the NDC. And several of the concepts that I mentioned are in the NDC. And I dare say that, largely because there was this work in conjunction with the scientific committee. These are Chile's emissions separated by different sectors. Look at the black line. This is a time series that ends in 2016. And it is a bit noisy, but Chile has been increasing its emissions in recent decades, like most countries in the world. So, when Chile commits to being carbon neutral effectively, this is a commitment to change that curve and to implement a significant number of actions that will change the course of what would be our normal development without this commitment. And here are some elements. Here is the PIC year, the carbon budget, and the measures that many of them also appear in the NDC. So, you can see that indeed science through the IPCC 1,5 report, and through the work of the scientific committee, is that these concepts have been implemented within national policy. And beyond this, now I want to refer to the role played by CR2, the Center for Climate Science and Resilience. It is a research center, funded by our scientific agency, by ANID, within a program called Priority Areas. In other words, at some point the country thought about which are the priority areas for the country. Climate change appeared within them, and since then, we have existed for 8 years. The vocation of the FONDAP centers in priority areas is to produce science of excellence through science that is very robust, that has a high commitment to what it is to provide science with a sense of public good, through open and transparent science, which are the pillars that we have within the CR2. And in this context, since 2019, we have developed an observatory on climate change law, and this has been led by Professor Pilar Moraga, who is a lawyer and academic at the Law School of the University of Chile. And this observatory of the climate change law has monitored all stages of the law.
5 minutos, Maisa. Sí, esta es de hecho es prácticamente mi última lámina. El observatorio entonces le ha hecho ese seguimiento.
From the stage that was a draft law, the bill enters Congress in 2020. In August 2020, it is generally approved in the Senate. And in October, the minister proposes to the Senate's Environmental Commission, which is the one that now has to advance the discussion, resolving the indications that came to the project for its general discussion, that the CR2 participate as a technical advisor to help resolve all those indications. As far as I know, this is the first time that a research center has participated so closely in the development of a law.
En el desarrollo de una ley.
And it has been a very interesting, very challenging job that is taking us many hours. But CR2 took this on because it is part of CR2's vocation, and because we are convinced that it is an urgent law. And we have a window of opportunity while Chile has the presidency of the COP also to advance this law. I would like, in the last 2 minutes that I have left, to reflect on something that seems to me to be too obvious. And that is, in 2020 we are experiencing a pandemic. That in some cases could have left the discussion of climate change in the background. In Chile in particular, during 2019, with the presidency of the COP on climate change, it was very high in public discussion. And with the pandemic, I would think that it went to second or third place. But, from what I could mention, we are pretty far from that. A lot has happened in the past year. What I show you here, on the black line, are the global emissions of the planet. I previously showed you those of Chile. But you see that it is a bit the same. It is a line that is increasing. That's our trajectory. And on the other hand, science tells us that, by 2050, we have to become carbon neutral. And therefore, from today, hopefully yesterday, but very soon, we have to turn that curve and get to zero. And we have 30 years left. And on the one hand, I would like to argue here, the pandemic shows us a world that is in crisis. And in 2019 we were talking about the climate crisis. In 2020 we are talking about a health crisis. In 2019 we were also talking about a biodiversity crisis. In Chile there was also a social crisis. So we live in a world with crisis and high levels of uncertainty. And what I would like to say is, in order to resolve these crises, I believe that it is essential that there be close accompaniment by science. In order to cope with this uncertainty and successfully face these multiple crises, the road is full of obstacles, and the next 30 years, and the next 10 years in particular, these obstacles are going to remain. We live in a very dynamic world, and science, I believe that, in that sense, it can play and should play an important role in accompanying our societies, so that we can overcome these obstacles in the best possible way.
Thank you very much, Maisa, for that perspective and the urgency taking measures with regard to carbon emissions. We thank you also for sticking to the 20-minute time constraint. Thank you. Let me now introduce Daniel Klein. He is an attorney and an expert in climate change. He currently works at the UN climate change level, and he has been working at the Secretariat for over 7 years. He's been responsible for the coordination for a number of efforts, including the Paris Accords. From the interpreters, the speaker's sound is deficient. We're doing our best with her. Danielle, you have the floor. Welcome to the panel.
Sí, muchas gracias, maestra Sibel Villalobos, y un saludo a todos.
Thank you very much. Greetings all.
Solo saludar en español
I
también
just
al
wanted to say hello
magistrado
in
presidente Jesús
Spanish
Delfiano y todo
and
el equipo que me ha
also recognize Chief
invitado a
Justice
contribuir a esto.
Delfiano and the
Voy a
others who are
tratar
with
de
us. I'm going to
compartir mi
try to
pantalla.
share my screen.
Espero que sí funciona.
And I hope that this works.
Dígame si funciona. Ok.
Yes, it seems that
Muy
it is
bien.
working
Y
very well.
entonces, sí tuve el privilegio de trabajar
I
en la
had
Secretaría de
the
Naciones sobre Cambio Climático para
privilege
11 años, de hecho,
of working for, in
incluso
fact,
el
11
apoyo a
years
las
for the
negociaciones del
UN
Acuerdo de París, que
system
ya hemos
on climate
escuchado
change,
mucho
culminating in the
la
Paris
presentación de la
Accords.
profesora Maisa Rojas.
That
Además de la
Professor
ciencia,
Maisa
muchas gracias por esta
Rojas
presentación.
referred to,
La presentación
along
será
with the science. My
llamada El Sistema de
presentation
Naciones Unidas sobre
is
Cambio
called
Climático en
the
la
UN climate
década
change regime
decisiva
in the
sobre cambio en los
decisive
próximos 10
decade
años. Y a partir de ahora
of
voy a cambiar
2020
al
and
inglés porque
2030,
la
and I will
presentación fue
speak
preparada en inglés,
in
pero ya sé que
English,
los intérpretes
but
son
I know
maravillosos,
that the
muy bien
interpreters are
formados.
outstanding.
Entonces
Thank you
voy
very much from the
a
interpreters.
cambiar a
And so
inglés
I
ahora.
will now
So the
switch
UN climate
to
change regime in the decisive
English.
decade, the coming 10 years, we already heard that these are very crucial. I've structured my presentation in 4 parts. Why decisive? The science, we already heard quite a lot by Maisa Rojas about the scientific background. Then go a bit more into detail about the key components of the Paris Agreement architecture or the regime. Thirdly, look at the Paris Agreement and the Framework Convention throughout that decade. What can we expect? And some conclusions in the end. You have seen this graph just in the presentation before. This is from the 1.5 special report of the Intergovernmental Panel on Climate Change. As mentioned by Maisa Rojas, there are various pathways, but all have in common that more or less by 2050, we need to reach net zero emissions. And more than that, we need to move to negative emissions in the second half of the century. And it's also very clear and scientifically established that the slower we are in reducing those emissions, the more difficult it will be to compensate for that slow speed. And we are already very slow, as you all will be aware. So acceleration is absolutely critical in this decade. As, for example, Professor Johan Rockström here said already 5 years ago, basically the formula should be, broadly speaking, halving emissions every decade of the globe, of every country, of every citizen. It's a useful formula. It's very simplified, but that's what we should, at a minimum, have in mind for this critical decade we are in now. And on the right-hand side, you also see where we are now. Where we are already over 1.1 degree warming, and with current policies, we could even hit the 4 degrees at some point if all pledges are fulfilled. We are better, but we need more optimistic scenarios even to come below 2 degrees, let alone 1.5. That's from the Climate Action Tracker. We also have every year the Unep emissions gap report that expresses this again in a dramatic way. You see here the current policy scenarios are far above the 2 degrees range, with the nationally determined contributions being fully implemented, the unconditional ones. We still have a 32 gigaton CO2 emissions gap, and with the conditional ones fully implemented, conditional upon international support, we still have a 15 gigaton gap, and that's the latest UNEP gap report from the year that just passed, 2020. In the words of UN Secretary General Antonio Guterres, the decisions that we make now will determine the course of the next 30 years and beyond, and emissions must fall by half by 2030 and reach net zero emissions no later than 2050. And at the same time, we know that we are already 1.1 degree warmer and are not on track the observations have shown that the last 10 years was the warmest decade on record. What is the international response? Maisa Rojas has already alluded to it. We have the Paris Agreement. It sits, legally speaking, under the United Nations Framework Convention on Climate Change, adopted in 1992, 3 years after the IPCC was established. The first legal attempt to curb emissions was done through the Kyoto Protocol. As you are aware, adopted in 1997, included only obligations for developed countries, industrialized countries, and set up a system of commitment periods, 5 years in the first commitment period and 8 years in the second commitment period, which did enter into force just before it expired, which is important to verify compliance, at least with these commitments, which are very modest, by those countries like the EU or Norway or others who remained in the Kyoto Protocol for the second commitment period. But most importantly, since 5 years ago, we had the anniversary a month ago, the countries of this world adopted the Paris Agreement. It entered into force in record speed. We have now 189 parties without the United States. In a couple of weeks, it is expected that the United States will re-enter the Paris Agreement under the new president. Then we will be at 190 parties. Just the general characteristics to recap: it's a legal instrument adopted under the Framework Convention. It's a fully fledged treaty under public international in its own right. We can see that from the content. It has party obligations, but also from the final clauses, ratification requirement, entry into force, and also indications, Article 15, that established the mechanism to promote compliance with its provisions. So compliance with provisions is in legal terms only possible with legal provisions that are internationally legally binding. Of course, the content depends on the wording and the crafting of these provisions. A second key characteristic was, at the outset of the negotiations, it must be universal. It must be applicable to all. One of the key elements that puts that into practice is the nationally determined contributions that each country itself brings to the table. We will look at that in a moment, and we can characterize its architecture as a hybrid approach. There are top-down guidance elements and then bottom-up action and support from the parties. What is this top-down guidance? It's very well known. The first part of the goal of Article 2, paragraph 1 of the Paris Agreement. Countries committed to strengthen the global response to the threat of climate change by holding global temperature increase to well below 2 degrees and pursue efforts to limit it to 1.5 degrees above pre-industrial levels. That's complemented by Article 4, paragraph 1, which sets the more specific goal of peaking of global emissions as soon as possible and a rapid decline thereafter in order to reach net zero emissions in the second half of the century. We should bear in mind that it says also an adaptation goal in that same article, which is to increase the ability of all countries to adapt to climate change impacts and to foster climate resilience. And thirdly, it also established a comprehensive finance goal to make all finance flows, not only public, private, all finance flows around the globe consistent with a pathway towards low greenhouse gas emission and climate resilient development. And many international or national climate institutions are coming to grips how to contribute to make this goal a reality. Normative force is arguably the same for all these three elements of the goal. Another top-down guidance element are the principles. We know common but differentiated responsibilities and respective capabilities already from the convention. The UNFCCC, it was very strict, divided into Annex 1 countries, non-Annex 1 countries. This is not the case in the Paris Agreement anymore. It's implemented, CBDR is implemented in the light of different national circumstances. but it's still present. It's present in the leadership role by developed countries. It's present in the support that developing countries are entitled to receive, special circumstances of least developed countries, concept of equity. But very prominently, the Paris Agreement adds very strongly the notion of best available science, particularly in Article 14 around the global stocktake, which we will see in a moment. The precautionary principle was already underlying the Framework Convention, and two new concepts which were in this form not contained in the UNFCCC and the Kyoto Protocol is the principle of progression, so that countries have to come with efforts in regular intervals that are better than those that have done in the past. And secondly, they always, for each nationally determined contributions, have to come up with the highest possible ambition. It's Article 4, Paragraph 3 of the Paris Agreement. These top-down guidance which was collectively agreed by 196 parties in Paris, inform the individual action and support. Most notably, Article 4, the national determined contributions, which are to be communicated by each party to the Paris Agreement every 5 years. They need to adopt domestic mitigation measures which are aimed to achieve these NDCs. The first intended nationally determined contributions, INDCs, were received in 2015, and upon ratification, at least for the large majority of parties, they were converted into the first NDC. But at the same time, the Paris decision of 2015 also asks all parties to come forward with the next NDCs or updated NDCs in 2020. De facto, they are still coming in. And we didn't have a conference of the parties this year, so it will be very interesting what will be on the table in terms of new and updates by COP26 in Glasgow at the November this year. You can find these nationally determined contributions on the in the registry of the UNFCCC Secretariat. Just type in Google NDC registry. It's probably easier than going through the website. And they will also always find the latest numbers. We have 190 parties submitted their first NDCs and already 8 submitted their second NDCs, which is a bit of a mix, sometimes an updated one, sometimes one that relates particularly to the second half of this decade, so 2025 and 26 onwards. As I said, we also have an adaptation goal, and all parties need to engage in adaptation planning and communicate an adaptation communication to the world, should do so, at least. And this will also play a role in our collective stocktake that we will look at the moment. And the support, as I mentioned, includes financial, technology, and capacity building support, notably the obligation of developed countries to provide and mobilize climate finance, not only public money, but also private investment. So the goal, already from Copenhagen and Cancun 10 years ago, is now enshrined. Well, it's set in the decision to mobilize $100 billion per year, but now we are really into the implementation. This is the first year of this decade. There are other elements also in the Paris Agreement, Article 5, about conserving, enhancing sinks and reservoirs, notably forests. Article 6, which include cooperative approaches, notably market mechanisms that should also support parties to increase their mitigation ambition in particular. This is the last element of the Paris Agreement, which is still under negotiation in terms of its details, hopefully to be concluded at the end of this year, the rules how this should operate. Article 8, loss and damage, pérdidas y daños, particularly recognition of this Warsaw mechanism and all the work that is already underway in enhancing understanding and supporting action support to address loss and damage. The mechanics of the Paris Agreement require, because the content of the national determined contributions is determined by each country itself, requires a collective look at regular intervals. How are we doing vis-a-vis the science? Science is evolving, we know more every year, and technology is evolving financial means sometimes are increasing, hopefully. So we need to do better every year and every year. So we can speak of an ambition cycle that the Paris Agreement aims to establish, starting with the communication of entities every 5 years, being looked at what the Paris Agreement calls the global stocktake, balance mondiale, every 5 years, with the first one coming in 2023, and then every 5 years thereafter, always against the goals, notably the mitigation goal of holding temperature well below 2 degrees, have peaking as soon as possible, etc. This is underpinned by something I haven't mentioned, the long-term low greenhouse gas emission development strategies. This is understood as strategies how to come in particular to carbon neutrality, for example, or emission neutrality by 2050, but also then how to get there. The principle that I mentioned earlier come into play here and may even play a role in national court claims that citizens or groups may bring forward against their own government, whether their own nationally determined contribution presented by the government is really reflecting the highest possible ambition and progression. So these principles may gain further support and normative force through depending on how each NDC is embedded in national laws or not, how precise, but certainly they have to inform the nationally determination of these contributions. And the principles of good science, best available science will inform the stocktake, underline the stocktake. Let's conclude by looking through the timeline of the 10 years. In green, you see the global stocktake, which goes through various phases, but culminates in 2023 at the COP, looking at these collective of the aggregated action of all countries. And that in turn, then in yellow, informs the next round of NDCs. At least that's the design of the Paris Agreement, and parties should come forward with the preparation of the next round of NDCs in 2025. And another milestone is then moving towards 2027, 2028 to the second global stocktake, and so forth every 5 years. This is informed by the latest science, notably the IPCC. We already, the 6th assessment report is already underway. This is the timeline before we had COVID. There may be some delays, but the IPCC remains committed that this AR6, how it's called, is available in time to inform this first global stocktaking. The findings will start coming out basically this year and next year. And in another cycle, there will be followed by the 7th assessment cycle. There will have to be some adjustments because the IPCC cycle is 7 years, and we actually need this information to inform the next global stocktake by 2027 already. Just mention also the transparency regime. So yes, we have collective assessment, but we also have individual obligations to report every second year. We already had a transparency system in the UNFCCC, but it was not really unified. So we had an enhanced transparency framework, and we see that kicking in full force 2023, 2024. By 2024, each and every country has to submit such a first biannual transparency report at the latest, which will go through a review by technical experts and has to include mandatory and some additional optional information. This is then every 2 years, this will be repeated. So the second and the third and the fourth, etc. So every 2 years we will go through, we will have the reports of the individual countries coming in, how they are doing. Last element of this overall overarching infrastructure is compliance. We know compliance already from the Kyoto Protocol, that was very strict, but as I said, covered only the industrialized countries. We will now see the true-up period for the second commitment period, where the Kyoto Protocol Compliance Committee will determine whether all of these countries did comply with their, as I mentioned, relatively modest targets. Under the Paris Agreement, we also have a implementation and compliance committee, which has a more facilitative character, but and has to develop some of its details still this year. But potentially from next year onward, will be in a position to at least check on the hard procedural obligations, mainly obligation of each country to submit an NDC and to submit mandatory reports and information to the Paris Agreement Conference of the Parties. And it can also identify issues of systemic nature. Negotiations go on. I said the Article 6 rule, the approaches will hopefully be concluded this COP in 2021. We still don't have common time frames for NDC, so a common length, for example. This is in theory. On paper, these negotiations are open for many years, but it is also decided that this needs to apply at the latest for the NDCs from 2031 onward. So also the sooner parties can agree here on common parameters, the better. And they will also start discussing from the end of this year a new finance goal from the floor of the $100 billion per year, and discuss how to move forward on the finance goal on the Article 2.1c that I mentioned earlier. The last aspect of this, let's say, regime I want to mention is the growing importance that the conferences and the whole international community attaches also to climate action. So yes, Paris Agreement only obliges sovereign states, but the non-state actors, so subnational governments, cities, private companies, and other private actors are becoming more and more active, and there's a growing recognition. There's some process around it. High-level champions are being appointed. You see here the current ones from Chile and from the United Kingdom that really try a lot to bring the action that is happening, let's say, on the ground, make it visible, and bring it to the international scene. So we see more and more coalitions of individual actors committing to achieving, for example, net zero emissions by 2050 or by 2040 earliest, and it really starts to cover all sectors, industry, agriculture, shipping, transport, you name it. So this goes deep, and I watched a lot of the conferences now in the Race to Zero dialogues in November, and this will become more and more important. Concluding, we are in a decisive decade for our planet that will fundamentally determine our conditions of living and our survival as a human species. The science is very strong on this, and I haven't even spoken about the panel on biodiversity and other international panels coming up with their yearly reports and assessments. On the emission side, we must halve global emissions by 2030, global ones. So as many developing countries will not halve their emissions in this decade, the industrialist countries must even do more than just halving them. And all sectors basically must undergo fundamental transformation. So the direction of travel is net zero greenhouse gas emissions by 2050 and negative emissions thereafter. The international legal framework is agreed and it is operational. So the world's nations have signed up to the Paris Agreement goals. I mentioned that there are three components of these goals: mitigation, adaptation, and finance. And the Paris Agreement is operational. The national determined contributions and what must be communicated every 5 years is agreed. Adaptation planning also has operational decisions underlying it. Finance, technology, capacity, and for support has operational decisions underlying this. And these architectural processes, the global assessment and the reporting, the transparency regime and the compliance regime also have their rules in place. So what is the focus? The focus is implementation. Implementation at the national level, even at the subnational level, of course, but taking the national level into focus here through legislation, to participation. There's clearly a role for the judiciary, and it's growing, but this is not so much the topic of my talk now, but at least give you some pinpoints as all countries must have domestic legal measures and policy measures in place, and there's a huge space for participation of stakeholders, and procedural rights, depending on the domestic context, can kick in here if the interests of parties or of stakeholders, indigenous peoples, groups, others are not included here. And as we've seen many cases coming up already now, where courts actually look at the substance of the measure. In the future, I would expect that the principle of highest possible ambition and progression could also be used by the courts, depending on the context. The climate science and how it's accepted and incorporated in the international regime informs these claims, informs also claims based on other rights, human rights notably. Professor Gerd Winter started speaking about this as well. We had some technical difficulties, but you're aware that there are courts, national, supranational, international courts already hearing cases where right to life, right to family life, right to health, to water, in some cases healthy environment, are connected with the climate change problematic. Rights of children, rights of future generations make these claims more plausible, and we see already claims being won, not only against governments, also against companies, of course. And I wanted to mention a last aspect. Companies and financial institutions are now also expected to align with the Paris goals. So we see more and more corporate strategies, policies, and plans in place that even pledge carbon neutrality by 2040 or 2050, or at least include climate proofing of risks and all the risks that are posed by climate change to their assets. So we can expect that there may be also more and more claims if there are violations of corporate laws or corporate or fiduciary duties by such entities. Thank you very much. That concludes my presentation. Sorry, went a little bit over time. I'm open to questions afterwards. Thank you.
Bien, muchas gracias, Daniel, por esa visión.
Thank you, Daniel, for the view mechanisms and tools that you presented in terms of climate change. For the first time, I find a favorable sense of the word ambition. It is nice to have areas where we can have ambition and follow the goals. And in terms of time, we will immediately go to Christina Floyd's presentation. She is professor of the Department of Public and International Law in the University of Oslo. She is a specialist in environmental law, and she has been negotiator of the Norwegian country. She is vice president of the International Right Association and candidate for conservation of nature. Christina, thank you very much for being here with us. You're welcome, and you have your 20 minutes waiting for you.
Thank you very much, Justice Villalobos. Thank you for your kind words. And thank you to the organizers for putting together this very important fourth forum, an international environment or international forum environmental law. At this point of time, at this juncture, there is probably no topic that is more relevant and timely to be discussed, including amongst lawyers. And a wonderful hello from a very cold evening here in Oslo. I tried to share my screen. Let me see if that works. Can you see it? Yeah. So I will focus on my talk a little bit on the European context when discussing the role of law in addressing climate change. But I've been listening very carefully, and I think it's very interesting, and a lot can be learned by listening, from other colleagues from other parts of the world of how they use law in that global fight against climate change. Now, what I'll do in my brief talk, and I'll try to stay to 20 minutes, is very, very roughly addressed to where we need to go, but Maisa and Daniel have already said a lot about this. And then I'll give you some examples of climate legislation in Europe, which are very similar to the Chilean Climate Act that Maisa introduced a little earlier. And then I'll talk about climate litigation and what's going on in Europe in this field, just by giving you some example, because there is so much happening that I could use an entire hour talking about climate litigation. And finally, I'll offer some reflections about the social role of law and lawyers and justices in the fight against climate change. As I said, to make it brief, I just want to make 2 points about where we need to go. The first point is that this is written squarely into the Paris Agreement in Article 2, which talks about, amongst other things, about holding the increase in temperatures to well below 2 degrees centigrade and even down to 1.5 degrees. Now, this doesn't really tell us very much of what exactly needs to be done. And this is where Article 4 comes in, which Daniel already talked about, which says more clearly that to meet that goal, or to not overstep that guardrail of staying well below 2 degrees, what is required is immediate peaking of emissions, understanding that developing countries might take a little longer, and then rapid reductions with a view to achieving the balance between emissions and removals the second half of the century. And this again, and you saw in the previous slide that with red I indicated informed by best available science, this is where the IPCC comes in, and especially the report on 1.5 degrees warming, which squarely lays out that reaching that goal means the reduction of global greenhouse gas, CO2 emissions, to net zero by 2050. And net zero means that not everything, of course, can be reduced to zero, but what we can't reduce to zero has to be balanced and removed by uptakes in forest or soils, or technical solutions like carbon capture and storage. But we have to have a net sum of zero. And importantly, as Maisa also indicated, the longer we wait until we get to net zero, and the longer we emit in the meantime, the more we have to get to negative emissions below zero in the second half of the century. That later part hasn't really sunk in entirely of what that includes and what that means for the world in general to stay in the negative side of emissions until 2100. But this is what science tells us, and I think this is something we have to chew quite a bit on in order to make this comprehensive. So where we need to go is immediate reductions of emissions to reach global carbon neutrality around 2050, full decarbonization of the global economy, which also means that some countries may need longer to get there, which in turn means that those countries that can reduce their emissions and have significantly contributed to climate change have to go down as soon as possible. There is no time, there is no excuse for any delays anymore in order to enable everyone to reach carbon neutrality by 2050, which also means increased removals either in forest or lands, or as I said, in bio energy with carbon capture or carbon capture and storage. And then after 2050, carbon neutrality. So this is very important to understand where we need to go in order to understand what role the law has to play in this context. Now, Daniel gave this very comprehensive overview over the Paris Agreement, and I assume that most of you know that the legal obligation that states have, or the core legal obligation, is to submit and to communicate these NDCs every 5 years. But the content, what the countries write into their NDC, the substance, that is not legally binding. That is something they have to report on, and they have to provide information, but it's not legally binding under international law. What the emission reduction targets are that countries determine on their own and put into the NDC and then communicate to the world. And this is exactly where domestic and national legislation comes in. Because the Paris Agreement is an international agreement, countries that are now parties, hopefully 190 soon, had to ratify or accept that agreement and have to implement their international obligations into domestic legal systems, laws, regulations, what have you. And many, many countries have done that so far, or still in the process of including their targets, their timetables, their reference points that they communicate internationally under the NDCs in their national legislation, in their national acts and regulations. They set up processes, they set up national institutions, they set up national reporting requirements to the parliament, for example, and they define their national level of ambition. And here these principles of progression and highest possible ambition come in. So we find them reflected in domestic climate laws. And this is what makes them legally binding, something we don't have under international law, but we see this now coming in domestic legal systems. That is what makes them binding. And once they're legally binding, as you know, it also becomes legally or judicial reviewable by courts, depending, of course, how it is written into domestic laws, and that differs from country to country. But we've seen a lot of examples and more examples coming forward where courts, judges actually look at these national legislations and look at whether what governments do is consistent with what they themselves agree to in their domestic laws. Just to talk a little bit about climate legislation in Europe, and you see that slide which I put on the right-hand side, which indicates the color in the dot indicates the darker it is, the higher the greenhouse gas emissions are from these respective European countries. And the bigger the dot is, the larger is the number of climate acts and laws that these countries have adopted. So you see a correlation of a lot of dark dots, which means that those countries which emit a lot of greenhouse gases seem also to have the highest numbers of legislation acts that deal with the various aspects of climate change. And as you know, climate change is something that cuts across all sectors, where transport or building or agriculture. So we have a lot of different legal instruments that deal with different aspects of climate change. I just very briefly want to run through 4 examples. And we see kind of the same structure in all these 4 examples. The first one is the first climate act that we had in Europe. That's the Climate Act of the United Kingdom from 2008 already, which fairly recently was updated, and now it contains the legally binding target of net zero emissions from 2050. So we have that target from the Paris Agreement, informed by science, which is not in a strict sense legally binding under the international law, but it is included in a domestic act, and here it becomes legally binding. The UK Act also establishes 5-year carbon budgets in order to meet that long-term target and to enhance the level of ambition every 5 years, similar to what then the Paris Agreement did. And it sets up reporting requirements by the ministers to the parliament. And importantly, and it's something that goes across all sorts of different acts, it sets up the Climate Change Committee, an independent expert body in order to advise the government. Then a couple of years later, we had the second Climate Act in Europe that was adopted by Denmark in 2014, which does not include a carbon neutrality target. Maybe that's something Denmark should think about and maybe revise that act a little bit. But it sets up the overarching strategic framework for a low emission society. And again, it establishes transparency and reporting requirement. And similar to the UK Act, also in Denmark, an independent academic climate council is established, again, in order to advise the government on the development of climate policies. And it sets also 5-year targets, shorter term targets, and 10-year national targets. 2 more acts, one from 2015 from Finland, which sets up the legally binding target of 80%. So again, we have a quantitative target which becomes legally binding through national legislation. It's similar to the other acts that has a planning and monitoring system, and provides these plans that are meant to increase over time, and also establishes an expert body to support planning of climate policy. I think this is an interesting development that all these countries seem to rely on academic and civil society input by setting up these independent bodies, committees or panels. And finally, my own country, Norway, has adopted its Climate Change Act in 2018, so it's the most recent one. And it also includes the carbon neutrality target now in 2050. It's framed as a low carbon society, but it has recently been amended to include a carbon neutrality target by 2050, and again has reporting requirements towards the parliament and sets up 5-year plans. So this is an interesting development where law in terms of legislation is a tool that takes the Paris Agreement, because all these acts refer to the Paris Agreement, and puts it squarely into the domestic legal framework and makes these targets legally binding and enforceable and judicially reviewable. And then finally, within the supra-regional level, the European level, we have an interesting development. You may have heard about the European Green Deal, which is the environmental deal, environmental policy cutting across biodiversity and all sorts of environmental challenges within Europe. It contains references to carbon neutrality, to biodiversity, circular economy, but amongst many things, it also contains the proposal for a European climate law, and that law, and it's a proposal so far, there's still one final step missing to adopt it, but that law, and I just wanted to show you this here, in Article 1 talks about or sets out a binding objective of climate neutrality in the European Union by 2050 in pursuit of the long-term temperature goal set out in the Article 2 of the Paris Agreement. So this is a very specific, very clear example of how the Paris Agreement is taken and put into this regional European law, which becomes binding once it is adopted. And this is just continued and made more specific in Article 2. This is a recent development and something that is very interesting to follow. So going or leaving legislation, moving in my last couple of minutes to litigation. Of course, this is a fascinating development in your part of the world as much as everywhere else, it seems, where climate cases are just mushrooming and are being heard by many, many courts. There are many different types of cases. There are a lot of claims and suits against governments, against states, but we also, or state entities, but we also have climate litigation against corporations and even against individuals. So there's thousands of cases, most of them in the United States, but also, of course, all over the world, we see an increase in numbers. I will only briefly talk about these cases that deal with, that are brought against governments and deal with emission reductions or with human rights. And I just give you some example, but you see from that whole line that there are all sorts of cases that also deal with procedural requirements of environmental impact assessment, access to information, public assembly rights, biodiversity protection, where it links back with climate change, and so forth. So there's a whole host of different cases that are currently being brought and tried, and some have been decided all over the world. And this is a graph from the 7th Center of Climate Law with Columbia University in New York. The 4 cases that I want to very briefly mention are from the Netherlands, from Ireland, from Norway, and then a supranational case at the European Court. Thank you. At European Court of Human Rights. The Agenda case, you may have heard about it because it was the first of its kind and it raised a lot of attracted a lot of attention, was brought by the Agenda Foundation, a civil society foundation. It's a made of words, contained urgent agenda, a foundation which took upon itself to bring a case against the state of the Netherlands, claiming that the ambition, the climate ambition of the Netherlands climate policy was too low. And the Supreme Court of the Netherlands, in the final instance in 2019, decided the case to the benefit of the claimants, the Agenda Foundation, and found that yes, indeed, the Netherlands did not act in accordance with its duty of care under Netherlands or Dutch law, in having an ambitious enough climate policy and raise the ambition from 20 to 25% of emission reductions by 2030. And the Supreme Court also found that by having a non-ambitious climate policy, the state of the Netherlands was violating the Article 2 and 8 of the European Convention on Human Rights. That's the right to life and the right to private life. So that was a very important case, and it has had repercussions ever since. The second case was decided by the Supreme Court of Ireland, brought against the government of Ireland by Friends of the Irish Environment. And that case concerned an implementation act of the Irish National Climate Action and Low Carbon Development Act. And that implementation of mitigation plan that was so unclear, it was very difficult to understand what exactly is the government going to do in order to implement the act. And but in the final instance, the government, the Supreme Court said that an act has to be sufficiently specific and clear, and therefore squashed the mitigation plan just because it was not clear enough. So that's a very important finding, because it said you can't just say something when nobody understands what it is. You have to be very specific, very clear of how exactly you're going to implement your national acts and legislation. The third case was just recently decided here in my own country, in Norway, by the Supreme Court. That was not exactly a success, but it was nevertheless a very interesting case. Greenpeace brought a case against the government of Norway, claiming that licenses to look for more oil and gas reservoirs in the Barents Sea up far in north, these licenses would lead to more production of oil and gas, and that would contribute to climate change. And thereby, handing out the licenses, the government of Norway was violating a constitutional provision to a right to a clean and healthy environment. Now, the Supreme Court of Norway, just right before Christmas, on the 22nd of December last year, decided this case. It did not follow the appeal, and it was decided in favor of the government of Norway, but primarily upon the reasoning that the provision in the constitution, the Norwegian constitution, does not contain a judicially reviewable right. That was a surprise to really everyone who worked in Norway on constitutional law, because the constitution says that every person has a right. Now the Supreme Court says this cannot be reviewed by the Supreme Court only in circumstances or situations where the government acted ultra virus or with bad intentions. So this is almost never, but it was nevertheless a very interesting case to follow, although it was unsuccessful. And finally, maybe the most recent and most exciting development is a case which was brought by those 6 children and young persons that you see here on my slide from Portugal to the European Court on Human Rights. European Court on Human Rights is kind of the equivalent to the Inter-American Court on Human Rights in your part of the world. And these 6 children brought this case against 33 member states to the European Convention on Human Rights, including Norway, by the way, and claiming that by not having high ambitious climate targets, these 33 states are violating the right to life and the right to private life of these children and young adults, because they're facing a certain uncertain future, a future that is defined by climate impacts. This case recently was
One extra minute.
Thank you. By the European Court on Human Rights, and will be heard in the months to follow. But it's going to be very, very interesting to see whether and how the European Court on Human Rights is actually deciding this case. Just let me wrap up in that last minute. So what I said was that the Paris Agreement, informed by science, by the IPCC, sets very clear climate goals, for example, of carbon neutrality by 2050. Now, lawmaking is happening, legislation, but it is slow. It's a slow process to translate those international targets into national law in order to make them legally binding, but we have some examples that I showed you. Now, political action is also coming about, but it is still slow. It is still inefficient. It's still inadequate, and partly not in line with the Paris Agreement, or not even in line with national constitutional or other legal provisions. And this is the role where the judicial system comes in, where lawyers, where judges, where justices come in, because they're asked and tasked to hold governments accountable to their constitutional or other climate laws, for example, in the Governments of Ireland case. And they're holding governments accountable to their commitments under international law. Of course, that depends on the legal system in place, but international law can be and has been used to interpret constitutional national provisions, or to interpret a duty of care, due diligence obligations, for example, or human rights obligations. So these international provisions and principles that we have, for example, progression and highest possible ambition, can and should and have been used as legal interpretative tools for domestic climate cases. So law, legislation, and litigation have a crucial role to play in that rapid, sustained, and effective transformation that we need to see towards a decarbonized world. And then, as Daniel said, we have really 1 decade left to turn the wheel, to turn this all about, the crucial decade. And law and lawyers are an important tool in that process. It's a governance tool to bring about change. And in light of slow legislative and processes, judges and courts are asked to play a much more progressive role. I know that Justice Antonio Benjamin from Brazil wasn't able to attend, but he spoke very highly and very passionately about the role of lawyers in that fight. And he said it's an inevitable topic that lawyers need to engage in, judges and courts need to engage. There are challenges to the judiciary, yes, of course, the urgency of the problem, the amount of scientific data, the balance of power. These are all questions that need to be asked and answered, but it should not prevent the judiciary from engaging in that important fight. Who else? Who else, if not the third pillar of power, can make a difference where legislation and political will is slow or missing? Because, and I just want to finish with the words of the Portuguese children that have brought this case to the European Court of Human Rights, because it is an emergency like no other. Thank you very much.
Cristina, muchísimas gracias por esa perspectiva de la
Thank you
relevancia.
very much, Christina, for that very important presentation on domestic processes and international processes. Each country, of course, has specific responsibility and specific actions, and this has been a fascinating presentation, fast-paced, but very interesting. Thank you very much. Lastly, let me introduce our final speaker, who is a geographer and a specialist in climate risk management. He has worked in Latin America, Asia, and elsewhere. He is currently the director of climate at the WMO and leads the risk reduction team within the UNDP and has worked with the World Bank. Maxx, welcome. Thank you for joining us today. You have 20 minutes. Thank you, Madam Justice. Ladies and gentlemen, dear colleagues, it is a pleasure to be here. Good afternoon. And I am thrilled to be able to speak here on behalf of the World Meteorological Organization. If you will allow, I will be speaking in English so that I can be more specific and hopefully more efficient in the use of time.
La pantalla.
Let me share my screen.
¿Lo ven?
Can you see that? Yes.
It's perfect.
Okay. Just a brief bit of context for the 10 slides that I'm going to present. The World Meteorological Organization is the United Nations system's authoritative voice on weather, water, and climate. And every year, with contributions from our member states, as well as the experts in the WMO network, we prepare a report on the state of the global climate, and we submit it to the United Nations Framework on Climate Change Convention. And the reports that we submit complement the IPCC reports that some of the other panelists have presented. So the data for the last 2 months in 2020 are still being processed, but I'll present some information from our provisional report, which we just released a month ago in December, that shows the current state of the climate. And I think this will support what some of the other panelists have been saying in terms of the urgency required now for action. So this is the temperature trend from pre-industrial times to today. And when we recall that the ambition of the Paris Agreement is to keep the increase to 1.5 to 2 degrees above pre-industrial levels, already in 2020, it's one of the 3 warmest years on record with an average global temperature of about 1.2 degrees above pre-industrial levels. And that is despite a La Nina event, which is underway now, which I'll talk about later, which normally would dampen the warming trend slightly. The preliminary data for 2020 suggests that 2020 will be virtually tied with 2016. And 2019 as the 3 warmest years. And 2016 was a year when we had an El Nino event, which tends to increase the global temperature, and which up until that point was indeed the warmest year on record. So now El Nino, La Nina, it doesn't seem to matter. The temperature just keeps going up and up. The first thing I'll show on this slide, if you see in the lower left that blue blob over the ocean right off the coast of Chile, that's the La Nina. So it's such a large area of cool ocean surface temperatures that it does reduce the global average slightly. But we also see in the upper right, in the Arctic, that there was a very high degree of warming. The warmest temperature ever recorded above the Arctic Circle was in Siberian Arctic in Verkhoyansk. It was 38 degrees in June. That's you know, unheard of. So the warming is not you know, uniform, obviously, and some parts of the planet, particularly the Arctic, are becoming global warming hotspots. Now, as has already been explained, this is the warming is being driven by increases in the levels of the principal so-called greenhouse gases, methane, carbon dioxide, and nitrous oxide. And we see that all 3 of those reached record levels in 2019, which is the last year for which we have measurements for concentrations in the atmosphere. And Dr. Rojas explained very clearly the difference between emissions and concentrations. The emissions are, you know, when the gases come into the atmosphere, but the concentrations are what the parts per million actually are as a result of the emissions. And I won't talk much about the effect of COVID. That was also already previously covered, but just to put the variations in the concentrations in the atmosphere due to COVID into perspective, the effect of all of those emissions reductions due to the slowdown in economic activity on concentrations of the gases in the atmosphere is less than the interannual variation that you see in the little green lines that are going up and down that are caused by the seasonality in the year, where the vegetation absorbs carbon dioxide and other gases and then releases it again. 90%, over 90% of the heat that's trapped by those gases is absorbed by the oceans. And in 2019, which is again the most recent data that we have, the ocean heat content was at record levels for all the different depths in the ocean. And 80% of the global ocean surface experienced what we call a marine heat wave in 2020. And over half of those were moderate to severe. The warming is causing of the oceans is causing a thermal expansion, and that combined with the melting of the sea ice and the continental ice is causing a steady increase in sea level rise. We had a little bit of a decline of that in 2020 because of the La Nina event that I mentioned. La Nina tends to cause more of the global precipitation to fall on the land surfaces than it does in the ocean. And then there's a lag before all that precipitation comes back to the ocean again. And that's why the La Nina tends to dampen this upward trend just slightly. But like the global temperature, the sea level rise is not uniformly distributed all over the entire ocean. And in some parts of the ocean, it's much, much higher than the global average. And this is important because if you are a small island developing state or a low-lying or highly urbanized coastal area in these regions where the sea level is rising much faster, obviously the implications are much more severe than the global average trend. The Arctic sea ice, as I mentioned, this 2020, the minimum extent was the second lowest on the record. And this shows the precipitation anomalies that occurred in 2020 because of the acceleration of the hydrological cycle. The green areas were areas that in many cases experienced flooding, like in China, for example, and across West Africa, whereas the brown areas are areas that experienced drought. And in South America, there was severe drought over most of the year in northern Argentina and Paraguay and western and southern Brazil, as you see there. So it's hitting close to home. And there was also a major heat wave in September and October, especially in Brazil. And I think previously in 2019, you had some record temperatures in Chile, if I remember correctly. So I'm almost at the end here. Yes, I already covered this. This just shows some of the fires associated with the drought that I mentioned. I'll just conclude by saying that obviously, you know, these trends in the hydrometeorological indicators have impacts, and there were 10 million displacements that were recorded in South and Southeast Asia and the Horn of Africa due to hydrometeorological hazards and disasters. And perhaps even more disturbingly, the Food and Agriculture Organization recorded an increase in global hunger after many years and decades of improvements in that indicator. And they attribute a good part of that increase in global hunger to hydrometeorological factors. So we're seeing human impacts now, and of course the impacts on wildlife. This last bullet is just from Australia that recorded because of the fires that they had, that displacement and loss of wildlife. I don't know how they estimate these things, but of 2.5 billion animals. So I'll just conclude by saying that over 70 WMO members contributed information for what I just presented, including Chile, I should add, along with United Nations agencies that particularly contribute on the impacts. and that, as I mentioned, these reports, which we prepare annually, complement the findings of the IPCC. So it is a situation that does require urgent action, and it was very interesting to listen to the other panelists talk about some of the ways that that is being done and that could be done through judicial channels. So it's been a pleasure to be here, and I'll conclude my remarks there. Thank you.
Muchísimas gracias, Max. Esta presentación nos ha permitido...
Thank you very much, Max. We can see how climate change is evolving in our geography, in our spaces, in the spaces in which we interact with our environment, and making distinctions and identifying when we feel that we are victims of the consequences of not being able to appropriately control the rising world temperature. So this is certainly a call to attention, if not to arms, in the figurative sense, in terms of moving forward in a conversation that is certainly regulatory, scientific, and therefore highly scientific and technical in both senses. And this presentation has brought those two things together very concisely. Thank you very much, Max. It's been lovely to have you on the panel. We have a few more minutes available to us for a question and answer session. Let me start with Maisa, and I'll try to merge together some of these questions. Actually, maybe not. The first question is what you envision for environmental courts in terms of Chile's domestic law. That's one question. And the second has to do with key actions that you envision to be able to make progress. And the question is whether closing the hydroelectric plants is sufficient or not. I don't know if I have an answer to the first question. In terms of the second, I think it's urgent for this bill to be passed. We need this new legislation, and that is why we need to see progress. It needs to move forward effectively. We need to have legislation that works. In terms of CR2. Now, Daniel Klein's presentation was very clear on the structure of this ratcheting mechanism of the ambition every 5 years. All of those elements are within the new bill here in Chile. It also seeks to link the global goals to the national goals and see how that would be implemented sectorally and then spread out regionally throughout the country. So there's a structure there that would need to operate. Our objective in providing this technical support is to ensure that this happens, that we are able to get carbon neutrality, again, which is the end goal of the law, and to have a more resilient country. Now, the role of environmental courts in this context, I don't think that I'm in a position to give a clear response, as I don't really know how those courts operate, but I would expect that they would. The Paris Agreement, perhaps I'm not going to say this right, but each country sets its own ambition. So in that sense, it's a bottom-up system, which is different from Kyoto, which was top-down. But once we have a law in place that will require, for example, biannual reports that everything is working with a system of transparency and so forth, whether it's a carrot or the stick, so to speak, the stick does have a role to play, and I would assume that the stick role would be that one that would fall to the courts, assuming all of the goodwill of the country, that climate change must be addressed. It must be addressed because it will enable us to build a better country, to improve the well-being of our people at the end of the day. Thank you very much for that response, Maisa. Daniel, we have several questions for you as well, but we have several, but I'm going to ask you just one that has to do with these principles and international instruments that you've shared with us. To what extent can they be applied to private players, to private actors? And is it possible to take legal action in that regard? Are these agreements enforceable in the private sector?
Okay, muchas gracias. Estaba escuchando la pregunta en español, pero voy a contestar.
I will answer in English.
So the principles of the Paris Agreement itself are not directly applicable to private actors, of course. They are even not maybe directly applicable to states, but they have normative force and can be interpreted. But that said, I see, at least I see various avenues how private actors can be held accountable. First of all, as Christina Floyd explained, if it's translated into national laws, goals that the state wants to achieve. Usually these laws also include monitoring obligations and translate into targets for their own companies, etc. So indirectly, one can imagine that in court cases, for example, the government is also held accountable to hold their own national companies accountable. And we know that also from human rights cases. So it's not only that the government is obliged not to violate the right of life, but if it doesn't act against murderers in the country, that's an obvious case. If they are private, then still it violates positive obligations of the state. And turning that a bit further, in extreme cases, of course, there have been cases also in Latin America, I think, in terms of pollution, in terms of where serious violations of human rights happened through private actors. And there can be scenarios where then this can also be held accountable for in connection to climate change. And there is, for example, the case in Germany against a big energy company that is linked to glacier meltings in Peru, and maybe Christina knows more about that case. So we can already start to see connections being made in that sense. And the final point I want to make is the last aspect that I highlighted, that more and more companies and financial actors are expected to include climate risks and climate friendly policies into their whole business model, into their operational guidelines. And then we will very soon see more and more cases where the companies are held accountable by their own shareholders or externals if they don't make efforts at least to align with the Paris Agreement goals.
Muchísimas gracias, Daniel. Tengo entendido que a nivel de la
Thank you
OECD.
very much, Daniel. I understand that the OECD is also providing tools for the private sector to perform better. I also have many questions for Christina. I will try to summarize. There is interest in two important aspects, the challenges and in environmental litigation, and which are the principles that you believe that environmental law should do when there is a litigation in climate change aspects?
This is a very interesting question, but also a very difficult question to answer because it really depends on the legal system that we're looking at. And as you know, it differs from country to country, how the legal system is structured. But we are seeing a very strong push towards rights-based litigation currently, where rights-based norms, either constitutional provisions or provisions from the, for example, the European Convention on Human Rights, but this is also replicated within the American context and the Inter-American Court on Human Rights and its jurisdiction, where human rights are being used as a means to be reinterpreted or interpreted in the light of the climate challenge, even though, for example, in the European Convention on Human Rights, there is no mentioning of environment, let alone climate change. It's not there at all. But the right to life, right to health, right to private life are interpreted in an environmental and a climate change context now. And this is a development which may be the most promising ones, because when it comes to human rights, we have we have long-standing practice by courts, and now it's all focused into a new context. Another one, so rights-based litigation, another aspect or principle that we see is the one of due diligence that applies both to states but also to private enterprises, and Daniel has alluded to it. Enterprises do not function in a legally free or vacuum space, but they have their own obligations, and one of them is to conduct their businesses in a diligent manner. And here due diligence comes in as a legal principle very squarely, and it's being now interpreted in the light of what climate science tells us. And I think that interface between science and law is very interesting. It's very important because many of the legal principles are very general and abstract, but they're now being seen and interpreted in the light of what science tells us, which is a bit of a challenge for lawyers and judges to grasp with all the graphs and and numbers. But it's a fascinating development where the IPCC reports are referred to in judicial judgments and are used really to give meaning to legal terms.
Muchas gracias. Una respuesta clara, apasionada.
Thank you. That was a clear, passionate response and full of challenges. Thank you very much. And Max, I also have very complex questions for you. Maisa.
Oh, good.
Or Max. You commented that hunger is one of the consequences of climate change, but at the same time in the world, we have seen a tremendous amount of loss of food. Do you think that there is area to interact and put together these things and to resolve both? And the other interesting question is related to, you talked about human displacement due to climate and now reinforced by the pandemic. So what happens with animal displacement? What happens when different species need to be displaced? Because that is their response, the adaptation that they have. How will this be favoring the non-human displacements?
Okay, let me try to answer those two, as you said, complex questions. The attribution of hunger and food insecurity to climatic causal factors is not straightforward, because if we just take an example like a drought, That drought is interacting with vulnerabilities of the system through which people access food in the situation. And so when we have a drought in Brazil, like the one I showed, it's less likely to be associated with food insecurity than it would be if it's in, let's say, the Horn of Africa, where the vulnerabilities are much higher. So WMO, where I work, only tracks the climatological causal factors. The Food and Agriculture Organization, of course, has to decide to what degree those climatic factors are associated with these hunger outcomes. And these other factors, access, nutritional related characteristics of the population, healthcare, and so on, all would play a role in those outcomes. It's not just a climate related phenomenon. But then, of course, I'll just jump from there to the second question. Climate is not the only stress factor. The global pandemic and the economic consequences of that is now another negative stressor that is adding to some of these problems. And that, if anything, the negative consequences of the pandemic on the economies were probably a bit of relief for some of the environmental indicators like species well-being, because there was just less pressure on the environment, at least briefly, because of the reduction in the emissions and industrial activity and so on. So there are analyses in the IPCC that I won't try to summarize about the degrees to which animals and plants and ecosystems can adapt before they start to experience irreversible losses. And there are a massive extinction episode underway right now, which is not all due to climate. It's due to plenty of other socioeconomic pressures as well, but climate is certainly, again, a contributing factor to that.
Thank you very much, Max. Certainly, these are all very hard to digest, not only for people on the day-to-day activity, but also to specialists that have been confronted to this type of challenges. This is an unmeasurable challenge, I believe. We cannot even view the real dimension of the task that comes ahead of us. And this is, I'm saying it on a personal basis, really, because it is an individual, a national, and international challenge at all levels. Okay, we are just on time, so I would like to thank our wonderful panelists. Without your participation, this forum would have not had the wonderful participation. It has been an amazing privilege to share this session with you, and we would like to invite you to the afternoon session and the following subjects. Thank you very much. I hope you have a very good afternoon. We want to thank the participants in this second panel, and we will now have a pause. We will reconvene at 15:30, 3:30 p.m. on the third panel, which is about indigenous peoples, and the fourth International Forum on Environmental Justice. Good afternoon, and we will reconvene soon.